Hello, hello, hello. We're still admitting people into the room, so we'll take a couple minutes to kill a little bit of time and give people an opportunity to get all logged in. But good afternoon. Welcome back. Hopefully you can hear me. Maybe somebody can unmute and just say, yeah, Steve, we hear you, just so that I know I'm not talking to myself. Oh, there's some thumbs up. Yay. Thank you very much. Okay, so before we get going for today, we're going to give some of the stragglers a few minutes to get into the room. Are there any questions about yesterday? I know I asked that at the end of the session, and there weren't any then, but that doesn't mean we haven't thought about some stuff. Okay, so the important things about yesterday are that there's a bunch of things that are covered under employment standards, and that they cover everything from the type of information that we need to provide to people, how and when we pay people, when people get breaks, how they're terminated, if they're terminated, how we calculate what they're owed, vacation pay, public holiday pay, and then some very special things in the legislation that are very specific to employment and recruitment firms. And some of those things are that we must provide all of the information concerning the assignments we send temporary workers on in writing. And it's everything from the name of the customers and the contact phone numbers of the customers and the various registered names of the company, so they're not confused about who they're actually going to work for. We are not allowed to charge fees to a customer to recruit or hire a temporary worker after they've been there from 6 months from the first date of their assignment. We're not allowed to charge fees to candidates in order for them to receive any services from us whatsoever. And also, we're not including getting a job. That's a total no-no. We do hear about people in some third world countries saying, yeah, I had to give my first month's salary to the recruiter, or that's certainly not allowed in Canada at all, and in most countries around the world. And there is the new requirement for employment agency and temporary staffing agency services licensing that are now in the legislation. So there's some very special things there that are relevant to temporary staffing firms. Today, we're going to move on into some other areas of recruitment law issues, and these will apply across the board for us and for our customers. Some things are not. We're going to talk a little bit about some things like employment equity for federal contractors. And so if you're not a federal contractor, then I've got to find there we go. I can find the screen I'm going to share. If you're not a federal contractor, then may not be that relevant for you, but important to know in the event that you choose to be one in the future. And today's module is on legal aspects of recruitment. Everybody is in the same sort of module right now. We start off in the fall, and we kind of begin our year. We have our 6 sessions during the fall, and then 6 more during the spring, and then sometime during the summer, people write after they've finished their 6 modules, can write their exams. And then each year at the national conference, we make special presentations to those who have acquired their CPC designation during the year. So again, another good reason to show up to conference this year, and take a look at that on the website. We talked about this yesterday, about the various modules that are required, including the optional sales module. You can take recruitment or sales. I recommend that you take both in order to achieve your CPC. Just a little history so that you know, many, many years ago, well over, I don't know, 25 years ago, there were, and before that, there were 2 industry associations in Canada, the Federation of Temporary Help Services and the Association of Placement Professionals and Consultants. One association represented the temporary help and contract providers, And in fact, there were three. There was another um, NACCP. There was another one that represented IT contractors. And the Association of Placement Professionals and Consultants represented the staffing, the recruitment services industry. And since then, all of those associations have merged together and all operate under the ACSESS umbrella. And when the two associations merged together, ACSESS was created, and one of the associations, that represented temporary help workers and companies, was far more involved and advanced and prioritized the lobbying and training for legislation that affected the industry. So all the employment legislation, the things that we're talking about in these two sessions. And the organization APAC that represented the recruitment industry put its strong emphasis on training, on certifications and training. And they didn't really have a certification module, but they had a lot of core training that they provided. And the members of that association really looked for it. So when they hired new employees, they said, oh, you're going to take the APAC training in recruitment and selection, for example. And so when we merged together, we made the certification a national recognized certification, professional certification, and created modules in a more structured and rigorous process in order to achieve your CPC. And we aligned it with the CPC and the name, the CPC, with other organizations around the world that were using the same title. Obviously different content because of different legislation and so on in different countries, but fundamentally the same. So there's a little bit of a history. The actual certification was created when the industry associations all merged together to create ACSESS. And now you're part of that and benefiting from that. And again, I want to remind you that your final exam is a multiple guess, multiple choice exam, and that you don't need to memorize formulas and numbers. You need to remember, just understand concepts and where they can be found and the kinds of things that we talk about today, because no one expects you to memorize this stuff. We expect you to know that it exists and where to find it, and be fully aware of how that legislation and those things are created, because they change from time to time. Hence the reason why you don't need to necessarily memorize it unless you're a lawyer and dealing with it every single day. We talked yesterday about the Code of Ethics and Standards and the fact that your company is a member of the association. And today we're going to talk a little bit about human rights. We're going to talk about diversity, equality, and equity. I'm going to give you some of my opinions on that also. And we're going to talk about privacy legislation in Canada and how it affects us and your employees. And the kind of things that you also need to kind of reinforce with your customers to protect our employees' rights to privacy. So first, from a big picture standpoint, these are the things we're going to look at today: human rights laws and the Human Rights Act. So when we talk about laws, acts, codes, those are all words that mean exactly the same thing. Employment equity, we'll spend some time on that, which really has to do with creating equal opportunity for people. Diversity and equity, we'll talk about DEI, where my opinions are, and privacy. So starting off with human rights. So human rights is really about dignity, respect, and equality. And human rights is really identified, as we talked about yesterday, in the law of laws in the Canadian Constitution and the Charter of Rights and Freedoms. And this is where we sort of enshrine the principles of dignity, respect, and equality. And it's about how people are treated. And we look at it again. We talked yesterday about the various jurisdictional powers, federal and provincial. And so the Charter of Rights and Freedoms is federal, part of our Constitution, and it sort of dictates the rules, and then it dictates the guidelines, and then the federal government, for those federally, on your right-hand side of your screen, for those federally regulated industries like banks, telecommunications, railway, airlines, those federal and the federal government, those federally regulated industries have to apply to the Canadian Human Rights Act. And then each province, again, just like employment legislation yesterday, has their own Human Rights Act, and they are fundamentally similar. And the reason that they're pretty much the same is because the Charter of Rights and Freedoms kind of dictates the standards, and then the issues come up in common law. They come up in court cases and people saying, hey, that was I'm going to, challenge that on a charter challenge. And they find their way into law. And then, of course, each of the provincial governments finds a way to write them into or codify them and write them into their act. So we've got the Canadian Human Rights Act, which is for federal government, federally regulated employers. We have the Charter of Rights and Freedoms, the Charter, which affects everyone in all provinces, federally or provincially regulated industries, and then each provincial legislation. And, I just point out that this one in Ontario now is called the Ontario Human Rights Code. And quite frankly, many other laws in Ontario are called acts. And it seems to me that this is just my opinion or an observation that if federal legislation already exists and it's called the code, and we want to have the exact same legislation in Ontario, we'll call it an act. And if they created something that's called it an act, if they named it an act, then when we go to create something in the province, we call it the same name, the Human Rights Code. That way, at least people know, the difference, slightly difference in the names, which one we're talking about when we talk about them. That's not necessarily true. It just seems to me that it seems to be that way, that we don't have federal legislation and provincial legislation using the exact same name. Although they contain almost exactly the same content. So human rights legislation applies to all the following practices of employment. Now, keep in mind that human rights acts don't only apply to employment, but they apply to all aspects of Canadian life. Everything from your access to purchase things and your right to services and your right to rent properties, rental properties, and to loans, and to all kinds of things. You can say that, to access to schools and education. And so human rights legislation applies to all aspects of Canadian life, but there are a subset of those rules that apply specifically to employment practices. And they include things like recruitment, advertising, referrals, promotions and demotions, training, wages, application forms, what we're allowed to ask and how we conduct our interviews, the who qualifies for and how we decide who can be accepted into apprenticeships and how we deliver those apprenticeship programs, transfers of employment, pretty much any matter, benefits, any matter in employment that you can pretty much think of. We have to ask the questions and ask the question, does this comply with human rights legislation? And ensure that it does. So we talk about discrimination in the workplace or grounds for discrimination. And there are typically 11 grounds that are covered in federal and provincial legislation. And by the way, some of these titles or topics for grounds for discrimination, these areas of 11 areas of prohibited grounds, often sound the same. Like, for example, race and national or ethnic origin, to me sounds pretty much the same, but they're not necessarily the same, because race might mean where your original ethnic origin was generations ago, and yet we might identify with a different nationality, for example, of where you were born or where your parents were born. And so we often say very similar things in many ways to make sure that if people are being very specific and literal that we've covered off all of the bases. So race, national or ethnic origin, color, religion, age, sex, sexual orientation, marital status, family status, disability, and this issue of pardons, convictions for which a person has been granted a pardon, is always pretty topical, although it doesn't actually come up that often. We talked the other day a little bit about reasonable accommodation, and we talked about bona fide occupational requirements. So you couldn't say, for example, that a person laying sod, that it was a bona fide occupational requirement, they'd be free and clear of all criminal convictions, of which they have not been pardoned for. You couldn't really say that that was a bona fide occupational requirement. And as a result of that, someone might be, if you made that part of your hiring criteria, now, if you were laying sod inside a bank vault, maybe you could. So you have to make sure that there's some reasonable reason why someone might make that criteria available. So to talk a little bit about how laws are created, in this particular case in 1995, the Supreme Court of Canada held that sexual orientation was not included in the original legislation, although if the writers of the charter had known or thought forward, they would have used additional language, because when they talked about sex and when they meaning gender, they also were referring to sexual orientation. And so in the and during this presentation today, by the way, we're going to talk about some cases that have got old dates on them. And that doesn't mean our presentation is out of date. What it means is that very often when we describe how legislation is created, we look at the original landmark case. And it becomes the case precedent that allows us to have common law. And then that common law is very often then written into statute and written into codified law or statute law. And so when we talk about cases from the 1990s or early 2000s or even before, this is so that we can get an understanding of how these rules came about and how deeply entrenched they are since that time into our systems. And so in 1995, this Supreme Court of Egan versus Canada, the courts decided that, sexual orientation really should have been included. And so the federal government came along a few years later in 2000 and passed Bill C-23, which gave same-sex couples the same social and tax benefits as heterosexuals. So in and around that time, a lawyer by the name of Doug Elliott, he argued, for example, that Canada Pension Plan death benefits would go to same-sex partners, and as a result of that, they won the Supreme Court case saying that those partners were allowed to have rights to that CPP benefit. And then the government came along in 2000 and codified that, wrote it into law, and then further after that came along and said, we're going to create in 2005, we're going to create the Civil Marriage Act, which would allow same-sex partners to be able to go down to City Hall or off to their church or whatever and get a marriage license so that same-sex couples could be married. And so they codified that also. So here we have another one of those situations where the Charter of Rights and Freedoms and the Canadian Constitution set out some guiding principles. Someone went to court and argued that the guiding principles were not being adhered to, and they created case precedents. Then along came the federal government or a provincial government, and they created statutes to follow along to put it into code what those changes would be to basically remove a form of discrimination that existed in our society. So when we talk about discrimination, we talk about, sip time, hang on. Apologize for that. When we talk about discrimination, we typically talk about two forms of discrimination. There's bad discrimination and really bad discrimination. And so adverse effect discrimination is the bad discrimination, but not like super bad, because It's usually a policy or a practice that is unintentional and in an unwitting or an unforeseen way ended up having an adverse effect on an individual or a small group of people. And so, what are some examples of that? So, if you require an employee to wear a uniform that has a hat, say, for example, and we're going to show you a case in a little while about an adverse effect of discrimination that had to deal with Sikh headwear. So if you came along and said, we have a uniform, and I'll jump into that, I'll get ahead of myself, but the RCMP have a hat and they have a uniform, and it's there so that they look official and that they're highly identifiable, and it's got a badge on it on the RCMP hat. So there are some things that they're there for a reason. In the case of the RCMP, it's not for safety purposes, like a hard hat might be, but it is for identification purposes. And in fast food restaurants, it might be for marketing purposes or for food safety purposes that they wear some sort of headgear. And a person who wears headdress might, for religious purposes, might say, "Hey, I can't fit that hat on my top of my religious headgear," and as a result of that, we look at this notion of reasonable accommodation. And so we say, is this a bona fide occupational requirement? In other words, is there any way to get around this? Can we change it? Is there some way to accommodate these people? And if there is some way to accommodate people through a reasonable accommodation, then we could say, hey, so in the case of the RCMP, I think the solution was that they came up with a Sikh headdress that had an RCMP badge on it. And so people with that religious conviction could order that piece of the uniform, and it became an official part of the uniform, and they didn't have to wear the typical flat top hat that RCMP wear. So things like establishing a schedule that rotates, and that, every second Friday you have to, work on Friday evenings or whatever. Well, that doesn't work for some people who, in their religion, on Friday at sundown until Saturday at sunrise, that they're not allowed to work. And so for Seventh-day Adventists and some forms of the Jewish faith and other religions, that would be a pretty typical thing, not working Friday after sundown. And so this automatic assignment of a schedule without any consideration to accommodate the person's religious holidays or religious practices could be a form of discrimination. And so when people set out to do this, they say, oh, this seems to make sense, and it's fair, and it's open, and it's transparent, and it's predictable, and it's part of our union negotiation. And then they find out after some time that it is having an adverse effect on an individual. And the solution to an adverse effect discrimination is to provide an accommodation, a reasonable accommodation to that person. So I'll give you one more example. You have a company that says, hey, it's our policy to only buy furniture from this furniture manufacturing company, and the desks all have to be this size, and they have to be this model, and the chairs have to be this model. Everyone's treated the same. Every office looks exactly the same. It's all very professional. They've negotiated discounts and prices and shipping and availability and distribution and colors that match their brand. And then a person with a disability finds that particular height or size of desk or shape of chair doesn't work for them. Then once we find out that this policy doesn't work for the person with a disability, and disability is an area of prohibited grounds, one of the 11 prohibited grounds for discrimination, then the accommodation is to find that person, because it's reasonable to go and spend a similar amount of money for a chair or a desk that might work for that person with their specific disability. Now, adverse effect discrimination is very different from what we often hear about on the news and read about and see court cases about, which is systemic discrimination. Systemic discrimination happens when a business has a practice or a workplace policy, or some kind of government has a government program, that discrimination occurs on a recurring basis against a large number of people, and that once it's understood and seen, it might be very obvious what the outcome of that would be, that it is being unfair or treating a group of people in an unfair way. So in systemic discrimination, when we have this normal way of doing things, and it's got this negative impact on certain groups of people, then the solution is to change the policy. It's not to accommodate a person, although when you find out about it in the first case, you might go, oh, geez, let's accommodate that person, and then realize, this is more than just adverse effect. This is systemic. This is throughout the organization, and this is creating this outcome that was unintended, or even worse, intended. And so we need to change the policy. So having criminal background checks in the example that I gave you earlier about the person laying sod would systemically discriminate against people who have got a criminal background when it has nothing to do with a bona fide occupational requirement. Recruitment practice such as favoring or limiting just word to mouth has the impact of having only people just like the current employees applying for and getting hired for future employees. So if everybody in the company came from a referral of an existing employee, then it makes sense to think that if we don't have any people of a particular nationality or from a particular place or with a particular age, that only the people who are making referrals in our workplace would be referring people that have very similar backgrounds to them. So that's an example. Steering applicants to certain kinds of jobs. So saying, oh, you're a woman, so why don't you apply for the nursing job? And you're a man, why don't you apply for the manly job, for the truck driver job? Those types of things inside an organization would be systemic discrimination. So we've got all kinds of things like wording in advertising. As a matter of fact, we talked a little bit yesterday about the wording in advertising so that we cannot say, for example, only Canadian experience allowed or Canadian experience required. You can have experience required, but it doesn't necessarily have to be Canadian experience. I suppose there might be there. I'm not going to try to think of a strange example, but there may be a case where you would only know something if it, a Canadian tax rule or something, if you would have only done Canadian tax. So, the question is, if you're going to hire someone, them having that specific experience being Canadian, it would be very limited. So we're not allowed to put those things into our advertising. Certain customer preferences, about what school you went to, for example, might be a problem, or the way you look, of course, that would be a problem. Personality tests. Look, I'm really big on traits profiling. I think this is really critical in hiring people for certain jobs to make sure that they match the profile of the job and they're likely to do the things and behave in a way that is suitable for that particular job. In other words, don't hire accountants to be salespeople and don't hire salespeople to be accountants. If there's a particular personality type that makes an accountant better and a particular personality type that makes a salesperson better. But the question is, do we know when we give people personality assessments, what the criteria are being used when we get that report or that graph or that thing, and are we qualified to say those are the traits or not the traits that are suited to that job? I mean, are we professionals in knowing how the system works, how the data is analyzed, what the traits are of the job, whether that analysis of that person does have those traits, and then matching them together? So just blindly saying, oh, I'm going to use this, assessment thing and get them to do their colors or read their palm or something is just not good enough in order for us to, that can easily result in systemic discrimination. Of course, we talked about religious practices with respect to days of the week and times of the day and holidays. And I'm sorry, guys, I forgot to put my call on silent today. And so those creating policies or rules that don't take those things into consideration would be considered systemic discrimination. So age-based limits, weight-based limits, lifting limits, attendance policies very often can be discriminating against single mothers or young families or people looking after elderly parents. So just having a policy with doesn't matter the reason, no fault, usually doesn't work from a human rights perspective. Being 100% recovered from an injury, illness, or um, um, some form of temporary disability would be considered a violation of one of the 11 prohibited grounds. Pre-employment medical inquiries that don't align with, I think that there's been some reasonable court case decisions about making sure that a person is free of drugs and alcohol before they operate heavy equipment. But does that mean they have never taken drugs or consumed alcohol? And so we need to make sure that the policy that is in place is aligned with the job and the job requirements and the bona fide occupational job requirements. So in other words, we've got two types of discrimination under the 11 prohibited grounds. One of them is adverse discrimination. And so when we've got adverse discrimination, we accommodate the person through some sort of reasonable accommodation, and we consider whether there's a better policy. And in systemic discrimination, it's not a good policy, and we change the policy. So what is this word accommodation that I continue to use when I'm talking about this? And we put the word reasonable in front of accommodating because we don't have an obligation to just accommodate everyone, because sometimes the accommodation might be wholly unreasonable. The ridiculous example that I might give is that we've got a historic building that is protected and you can't modify or change under the law this historic building. And let's say, for example, it's a prison, and the only way to get into a certain area in this prison is to squeeze through this 20-inch wide slot in the walls. And it's designed that way so escaped prisoners, even if they got that far, boy, they'd have to turn sideways and really wiggle through. And then the guards could poke them and stop them from coming out. So that was a thing 200 years ago. In some prisons, they made these really narrow areas and windy hallways so that people, even if they got out of their cell, couldn't get out of the jail. And so now you're got people who are giving tours of this historic jail, and they're not skinny enough to fit through this place that is designed for very skinny spots. So to totally accommodate the person, we'd have to knock the walls down. We'd have to break the building and ruin its historical heritage protection. To reasonably accommodate the person, we would give a person who didn't fit through that skinny spot a job on the outside of the skinny spot, so they could do the customer service without having to go into that area of the building. So I don't know if it's a good example, but it's an example of where we were. It would be unreasonable to knock the building down, but it would be reasonable to reassign the person to a new location. So we talk about reasonableness in the accommodation. So very often, if there's a dispute over whether a person was discriminated against, they ask the question, is this a bona fide occupational requirement? We're going to come back to that. Is this really required for the job? And then, was there an effort at reasonable accommodation? And they might argue over what reasonable means. This much extra money, this new equipment, this different headgear, was that a reasonable way to accommodate the person? Or could you say, no way, oh, no way, everybody has to wear that hat? And that might be an unreasonable, that might have been a wrong solution because reasonableness would have applied. We've got some things like, let's say, for example, we don't advertise in certain languages in certain newspapers. These would be a reasonable accommodation. Or we might translate some of things into different languages inside our company, We might create apprenticeships programs that are designed for people of all ages, not just, as soon as you got out of school. For example, I think they made a movie about elderly gentlemen returning to work and becoming an apprentice. Installing software, keyboard features, things that now pretty much come on a phone and on a computer. You can push some buttons, but maybe buying some specific equipment or keyboards or seating or keyboard trays or large screens or text to voice that might accommodate people with disabilities or other reasons. And changing schedules, for example, would be reasonable to accommodate some people because of their religious practices. So we talked about the reasonable accommodation, but then we talk about this thing called a bona fide occupational requirement. And in Canada, we call it a BFOR, a bona fide occupational requirement. In the United States, they call it a bona fide occupational qualifications. They mean the same thing, but you can see they're slightly different. In Canada, it's a requirement. And so it is mandatory. And a qualification means, you're qualified for that job. So it's a little more loosely worded in the United States. And I think it's treated and a little more loosely in the United States with a BFOQ than we in Canada treat a BFOR. We treat our bona fide occupational requirements pretty seriously here. And what it means, a Latin word meaning, direct translation, the meaning absolutely necessary. It's real. It's justified in its existence. And so having a bona fide occupational requirement means, for example, that if you need to wear a hard hat because there's things swinging around head height that could hit you in the head, then it would be a bona fide occupational requirement that you wear this hard hat for your own safety and for the safety of others. You could make a case that that's necessary. And so it becomes a qualification. And then we ask ourselves, okay, if it is a bona fide occupational requirement, then we don't necessarily have to, and there is no reasonable accommodation, then we can use it as a criteria for hiring or a criteria for promotion or a criteria for raising a person's pay or for whatever the decision that you're trying to make in employment. And so the question is, first, is it really a bona fide occupational requirement, or is it just a suggested and kind of wanted and preferred qualification? And then secondly, can we accommodate it? And if we can't accommodate it, is the accommodation decision reasonable in the context of the work? So if it's going to cost $1 million and the person works in a job where they only generate $25,000 a year in sales, not reasonable to accommodate that person. So I'm not going to say it becomes legal to discriminate against the person now, because it's no longer illegal. It is, if there is a bona fide occupational requirement that cannot be reasonably accommodated, it is not considered discrimination. So it can become a legitimate criteria for the form of hiring. Now, of course, could employers look at these things and they say, hey, but if we split the job, if we split the schedule, if we moved to the location, if we looked at different equipment, if we looked at different software, we can reasonably accommodate the person. So most good employers are always looking at ways to find a way to employ the best candidates by selecting from 100% of the available candidates in the world or in the community. And when you've got some requirements that screen people out unnecessarily, you're not necessarily getting access to the best quality candidates from 100% of the pool. So let's talk about a couple little cases. Mr. Christie was employed at the dairy pool, and he became a member of the Worldwide Church of God in 1983. Again, we're going back to a case precedent, 1983. The church recognizes Saturday as their Sabbath and 10 holy days throughout the year. Members of the church are expected not to work on these Sabbath and holy days. Mr. Christie asked his employer for permission to take off unpaid, not paid, unpaid leave on these 3 days. In March, Tuesday, March 29th, 2 days, and Monday, April 4th, because they were considered holy days. He was granted the Tuesday off, but he was denied the Monday. And so he just didn't show up for work on Monday, and he was terminated. And so basically, let's use this one and say, okay, first off, is there a obligation to accommodate the person or look for an accommodation with the person because of, yeah, sure, because of religion. So we need to not discriminate against him because of religion. He lost his job and was going to be scheduled to work on a day that violated his religious practice. That's number one. Then we say to ourselves, was it reasonable to accommodate the person? And, as it so happens, this is in 1983. So dairies were not quite as advanced as they are right now. And I think this dairy was in Alberta. I'm not sure if it said here. And yeah, in Alberta. And at the time, what would happen is all of the milk would come in from the dairy farms and be collected over the course of the weekend, because people still milk their cows on Saturdays and Sundays. And they delivered the milk to the dairy, and it sat there all weekend, and it needed to be pasteurized and processed on Monday so that too many days didn't go by. So Monday was a pretty critical day for the dairy. And they felt that it was so darn critical that him missing that day of work was justification in him being fired from his job. Well, it turns out that there's lots of people that work in the dairy, and they could have moved some schedules around, and some people could have maybe worked a little bit of overtime without getting into double time or time and a half. And there was other ways to accommodate this. And so they found that, first off, it was not necessarily a bona fide occupational requirement. And even if it was, there was a way to reasonably accommodate him. And so they looked at this and said, this is systemic discrimination, because this would affect every single person who had the same religious beliefs. And so they needed to change their policy. In the second case, we've got the case of the CNR Railroad, which I've already pretty much alluded to. This was this, I told you about the case with the RCMP, but this happens to be a case with the railroad where they worked with hard hats, and the gentleman was suspended, and his union, he was an electrician, his union appealed for him. And so they came back and said, look, in the case of Mr. Binder, there was no shortage of maintenance electricians. At the CNR Railroad, at that particular location, there were lots of electricians. And there were lots of electricians' duties and stations and responsibilities. And there was lots of employees that specialized in those duties, stations, and responsibilities. And that the policy was in place for him to wear a hard hat for safety reasons. But if Mr. Binder were to work at some of the stations, there was no overhead or head safety risk whatsoever. He wasn't putting himself in any danger if he worked at some of the locations and stations. He wasn't putting anybody else in jeopardy, and he would be able to perform his duties while wearing his religious headdress without having a safety helmet. And this wasn't going to affect other employees or the general public in any particular way. The risk to him was negligible, and as a result, he was given permission to accommodate him to not wear his, to be assigned to stations that didn't have a head safety injury risk, and to allow him to not wear his hard hat at those locations. And so in his particular case, this was considered to be adverse effect discrimination because it wasn't across the board for a whole bunch of people. If it had been affecting a whole group of people, then they would have been considered systemic discrimination. But as we said earlier, when you've got adverse effect discrimination, you accommodate the person, and you consider whether or not the policy should be changed or could be changed to try to reduce the possibility of it happening again. So let's take a look at this little test of what we just learned. Which of the following is not a discriminatory practice? Denying someone goods and services and facilities or accommodation based upon a prohibited ground. Well, remember we said that we're talking specifically today about employment practices, but the actual Human Rights Act applies to everything in society. So of course that would be discrimination. Denying an employment opportunity based upon a bona fide occupational requirement. Now, so we've got a bona fide occupational requirement, and so we can write that into the job description. So we're going to see what the answer is here, but the answer really is it's okay. It's not considered discrimination if it's a bona fide occupational requirement, so long as we can't reasonably accommodate the person. Paying men and women differently, well, that would be discrimination. We're doing the same job. We talked yesterday about pay equity. We talked yesterday about pay equity and the steps that you can go through in the Employment Standards Act. Well, of course, the same thing would apply to the Human Rights Act, that as long as people are working doing work that is fundamentally the same and not having other criteria like performance or tenure or location or night shift or something like that. If you could explain the difference in pay, that's fine. But if it's just simply gender, absolutely not. That would be considered discrimination, systemic discrimination. We didn't talk about this, and I think we might, but I did talk yesterday about reprisals in the Employment Standards Act. Well, reprisals exist in pretty much every act. And so, of course, reprisals exist in human rights legislation. And so an employer retaliating against a person who has filed a complaint with the Human Rights Commission or with the Human Rights Office or with Human Resources against someone who filed a complaint for them, that would be considered discrimination. And of course, harassment. Harassment is really covered under a couple of different ways. Harassment is considered under the Human Rights Act. And harassment in some provinces, for example, in Ontario, is also covered under the Workplace Health and Safety Act in Workplace Violence and Harassment Protection section of the workplace safety. And so we come at it from a whole bunch of different ways to make sure that people are not harassed at work. And so the answer to this question is that it's not a discriminatory practice for B in denying employment opportunity based upon a bona fide occupational requirement, so long as a condition there isn't a reasonable way to accommodate that person. Another example, case number 3 in the Western School District, 1992. So we're still going back there to original cases. The Supreme Court restored the decision of the Council of Human Rights, which found that Mr. Smith was discriminated against by his employer and his union because of religious beliefs. And so in this particular case, it was a custodian who worked in a school, and they rent the school out on Saturdays and weekends and Friday nights and so on to groups like Cubs and floor hockey and whatever. And it is the policy of the school board that there's always a janitor on duty when they've rented out the facilities to a third-party group for safety and facility operational reasons, locking, unlocking the door, heat, temperature, windows, all that safety. all that kind of stuff. And this particular person didn't want to work on Friday nights or couldn't work on Friday nights because of his religion. And they let him go, or they tried to let him go. The union didn't stand up for him. And so they sued both the union and the employer. And the Supreme Court decided that it was no good because there were a lot of janitors in the system, in the school system, many of which really wanted to work Friday nights and extra overtime. And they could have easily just posted the job and assigned a janitor to work in that school. Now, this particular case of systemic discrimination, quite newsworthy and controversial, and honestly, over time, has just with Hockey Canada was sort of the thin edge of the wedge of many issues that Hockey Canada and the whole hockey culture needed to deal with. And it went well beyond this original case of co-ed dressing rooms for girls wanting to play in boys hockey and or transgender people with gender identity expectations, either wanting to share, other people not wanting to share, or having access to their own dressing rooms. And so in this particular case, the commission decided that the Hockey Canada needed to provide training to all of its Ontario-based trainers and coaches on gender identity and gender expression, including training on discrimination and harassment, particularly with respect to gender identity and gender expression. They need to amend their policies with respect to co-ed dressing rooms, which would be publicly posted in all the arenas and facilities that they operated out of, and to put it on their websites. And that the policies would include that a player has a right to use a dressing room that corresponds to the player's self-identified gender. The player must be addressed and referred to by a name and by pronouns corresponding to the player's self-identified gender. A player is entitled to privacy and confidentiality with respect to a player's trans status, and information about the amended policy and accessibility to staff, volunteers, and parents must be posted and available to everyone. So this is a typical outcome of a human rights case and a violation where there's a systemic discrimination found. Typically in a case when it goes to the commission and they have a finding, it can happen that they will penalize someone. No, I mean, it's not really that heard of that they'll restore somebody's employment. A lot of people don't want to go back to their employment. But maybe the employer gets penalized and has to pay a penalty to the person, has to pay them some kind of severance pay or some kind of penalty to them. Or they could force them to reemploy them, or they could force them to promote or transfer that person. But most often the solution is the commission, more often, the solution is for the commission to force the employer to amend their policy, because systemic discriminatory policies need to be amended and changed so they're no longer systemic, and to require some form of education and training and policy announcements and policy reinforcement. And it is said, I can't say this is true, it is said that often the cost of adhering to of doing the required penalties or requirements that are enforced by the commission can be far more expensive than just getting it right in the first place, training people and or not treating people badly. So a company might say, oh, geez, we'll fire them and, we'll give them a severance package of X number of dollars because that's what required by law. And then they come back and that costs them $50,000. And they come back and find out this training policy is going to cost them $2 million by the time they roll it out and meet all the standards. So Usually, there is when it is known and systemic, and the employer shows a disregard to improving it, then the outcome can be somewhat punitive. So let's test our knowledge on these 11 prohibited grounds. Number one, a policy provides benefits. We're going to take a break at 2:30. A policy provides benefits to some married couples, but not to others. This would be family status. So, say for example, a gay married couple wasn't allowed to join the benefits plan. That would be family status discrimination under the family status area of prohibited grounds. Number two, a person is denied a job because of a previous conviction of which a pardon has been granted. So let's talk a little bit about pardons for a second. So listen, it's okay to have a bona fide occupational requirement, if it is a bona fide occupational requirement, that a person be free and clear of criminal convictions in order to get the job. So for example, you don't want to have a person who has been convicted of previous theft and fraud handling credit cards and banking in their employment. So it would be reasonable to say you have to have a criminal background check and be free and clear of any criminal convictions for which you have not been pardoned for before you can have this job. So first off, we got to ask the question, is it a bona fide occupational requirement? Then the second thing is, if the person's been pardoned, that has the legal effect from a human rights standpoint of it never having happened in the past. Now, we hear about pardons in the news all the time because Donald Trump is famous for giving out pardons to the thousands of people who stormed the Capitol, and to his cryptocurrency fraudster to get him on his cryptocurrency team, and, all kinds of weird things. But generally in Canada, pardons are provided in two circumstances. If there's any lawyers, talk to a lawyer, maybe I might be simplifying this too much, but basically, if a person is found after the fact that didn't happen, that they were wrongly convicted, they can be pardoned of something. Or if such an incredible amount of time has gone by, they've served their entire sentence, they've shown themselves to be an entirely different person, then a government could say, hey, that thing that they did 40 years ago, we're going to pardon them for it. And remove it. It's basically removed from their record. And so when we talk about for which a person has not been pardoned for, that means it still remains on their record. And if they have been pardoned, then we're not allowed to use that past criminal conviction to apply it against our bona fide occupational requirement. It's very uncommon, quite honestly, to ask a person something, find out that they were pardoned, get a police record check shouldn't even show you that it even existed, but there's certain kinds of police record checks you can, and the police database is not perfect from province to province and police force to police force and federal database to federal database. So it could show up there. And we wouldn't be able to use it if it did show up. So it's an interesting thing. So the phrasing is, when you ask the question, for a bona fide occupational requirement, have you been convicted of a criminal offense for which you have not been pardoned? Is the question that you can ask, but you can only ask that question if the being free and clear of criminal convictions is a bona fide occupational requirement. Next one, disability. A female employee with an excellent performance record announces that she is pregnant. So interestingly enough, I think I'm on the right question. In this particular case, they would say, yeah, pregnancy would be considered a disability, which of course it's not really, but it's a physical condition, clearly a physical condition, that we would not have the ability to use to determine whether a person is qualified for the job or a promotion in a job. An employer assigns her employee to weekend shifts without recognizing that some employees observe the Sabbath and cannot work on those days. So we talked a whole bunch about that. By the way, the answer to the previous question was family status, but it also can be, I don't like the term disability, but it is a physical condition. And so the answer to the previous question about discrimination depends upon how or why they were discriminated. But if they were discriminated just because they're pregnant, then it's family status. And if they're discriminated because they said you can't physically do that job, it would be considered disability. Next question is the employer assigns an employee to work on the weekends, and that has to do with religion. And then the next one, an employer's physical fitness requires based on the capabilities of a 25-year-old instead of being based upon the actual requirements of the job. I don't know what the physical conditions of a 25-year-old are, so I'm not, but basically they're saying, hey, if you can't do what a 25-year-old person can do, you can't have this job. That's not appropriate. And I talked about this earlier. Is harassment a form of discrimination? And the answer to that is yes. So harassment in the case of human rights law has to deal with a form of discrimination that involves unwanted physical or verbal interventions that offends or humiliates a person. Generally, harassment is a behavior that persists over time. It's repeated. It's not a one-time event. It's a series of events. Now, we can consider a one-time event to be harassment under this legislation if the one-time event is so severe that it has repeated and recurring effect. But usually it has to do with the incident, plural, of harassment. And even from a date standpoint, it has to deal with when they take a look at the statute of when did this happen? You've got a certain period of time to complain about harassment. When did the last incident occur? Now, incidentally, when it comes to the date issue with respect to harassment and when did the last issue occur, so within 1 year, if we make the complaint about the most recent harassment within the 1 year, then that captures all of the previous events of harassment. If we wait for longer than 1 year from the most recent incident, we wait for 2 or 3 years, and we make a complaint about harassment of that most recent incident, then that incident is excluded from the complaint and does not capture the previous incidents. So, like most laws, people go into court. In this case, it would be the Human Rights Commission tribunal, and they argue the technicalities, not necessarily the spirit and intent. And so one of the technicalities with respect to the harassment legislation is that if you're going to be harassed, you have to identify and know that you're being harassed, and you have to complain that you're being harassed. You can't come up 2 years later or 5 years later and say, oh, that was harassing. Now, that's for human rights. Your criminal issues are different, and just making a complaint for civil reasons are different, but under this particular legislation. So harassment can occur when a person makes unwelcome jokes about any of the 11 prohibited grounds: race, religion, sex, age, disability, and so on. Any of the 11 areas of prohibited grounds. If they threaten you or intimidate you, if they make unwelcome or physical contact with you, such as touching, patting you, pinching, punching, oh boy, hard contact, physical contact, these can also be considered an assault, not only harassment. Where can it occur? Well, it can occur anywhere. Harassment doesn't have to occur in the workplace. If you are working for a supervisor and your kids play on the same hockey team, and your supervisor harasses you in the stands of the hockey arena, in employment legislation under the area of harassment, that's included. So it doesn't have to only be in the workplace. And again, as I mentioned, the complaint of harassment must be filed within 12 months. Within 12 months of the last or most recent alleged incident. They can go back further in time to describe incidents or events that you can demonstrate that are related to the last incident. So once you've made this occurrence, then you can say, and it led up to this last occurrence through this, and this. So once you make the alleged incident case captures everything before. Okay, multiple choice questions. Identify and select answers below that do not, we always do the do not questions, which do not constitute harassment. So let's look at the ones that do. A, discrediting the person by spreading malicious gossip and rumors. So we're not only, we're in this particular case, we're humiliating the person on a repetitive basis by creating a gossip or rumor. That would be considered harassment. Let's jump over to number C. Unwanted sexual advances that may or may not be accompanied by threats or explicit or implicit promises. Quid pro quo. We're going to talk about that in a moment. That, of course, would be considered harassment. Number D, making rude or degrading or otherwise comments. Harassment. Friendly gestures among coworkers, such as a pat on the back. Well, that can be considered harassment if you do it repetitively and it's unwanted. Isolating the person by no longer talking to him or her, denying them or ignoring them or their presence, distancing, not inviting them to meetings, putting them in a corner, sending them to the basement. Those can all be considered harassment. D and E, a friendly gesture amongst coworkers as a pat on the back. That is not usually considered harassment. It could be if the person who's being patted on the back makes a complaint and asks to not do that. Please don't touch me there anymore. Please don't touch me. And the person continues to do it. And particularly if they knowingly do it. Just like that. They got so upset about me touching them. You want to see touching? I'll touch them now. Oh, that would be considered harassment. Now, the first one, B, an isolated or single incident such as an inappropriate remark. People get angry and people say things and people have incidences and they accuse people of things and things are said in an argument and a disagreement and a discussion. And so being rude or being wrong doesn't constitute harassment under the law unless, one, it is repeated and we ask them not to do it, but they continue to do it. Or two, that event was so significant, so severe, that it had the same effect as being repeated over and over again, then it could be considered harassment. Now, the word quid, the Latin phrase, quid pro quo, translates loosely into meaning this for that, or something, this for that, something for something in return. And the term in itself, quid pro quo, is not necessarily a bad thing. So in bartering, quid pro quo, I'll make sure that you get this delivered early so that you guys can close down on your Friday afternoon shift in exchange for you giving me more business in the future. So there's a quid pro quo. There's a supplier saying, I'll do this favor for you once if you promise to do more business with me in the future. That's a quid pro quo. Nothing illegal about that. Nothing wrong about that. As a matter of fact, we should have had these implicit quid pro quos all throughout our life. Mothers and their allowance for keeping the room clean can be considered a quid for kids keeping the room clean, could be considered a form of quid pro quo. However, in the case of human rights legislation, when we refer to quid pro quo. We are never talking about normal, acceptable behavior. We're almost always talking about sexual harassment of some form or some form of inappropriate conduct between people. It occurs in a workplace when a manager or someone with authority hints towards or suggests to an employee that they might get something in return for some form of satisfaction that would be sexual satisfaction or otherwise. Changing work standards after an employee refuses and repeats to maybe, for example, go out on a date, asking the person out for dinner, and suggesting that they travel with them or that they ride in the car with them or that they do something, and the person says no, 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 and then the supervisor reprises against them by changing their work standards or their pay or refusing them a promotion. Disciplining or firing a subordinate who ends up in a romance, particularly a broken romance. So two people go into a romance that are willing adults that make that decision. I read the other day that 13% of marriages were people met each other at work, through work. I thought the number would be higher than that, quite frankly. But the 13%, according to the most recent study that I saw. And so it's not wrong that people meet each other and that they fall into a romance. What is wrong is if a company has a policy that says you need to disclose your romances and with coworkers, and you don't. What is wrong is using that romance for quid pro quo. What is wrong is having a romance or a broken romance and having a romance and providing a person a benefit, or having a broken romance and having a reprisal. And so these are all considered to be violations of harassment in the employment sections of the Human Rights Act. A job applicant who may be subject to this kind of harassment if the hiring decision was based upon the acceptance or rejection of sexual advances. So yeah, hey, a person might say, yeah, let's have our final interview out at the club on Friday night. That would be considered and could be considered a form of harassment. So a summary of the Human Rights Act, let's delve into that. The act in itself is the principle that all individuals in Canada have an equal opportunity for themselves and the lives that they are able to and wish to have, and to have their needs accommodated if there's if it's one of the 11 prohibited grounds and it is reasonable. The act is also meant to promote this equality by prohibiting discriminatory practices based upon specific attributes such as race, ethnicity, gender, and others, and may hinder or prevent a person from doing so. And so this is really about creating a level playing field for everyone and not making people feel different, feeling harassed, feeling that they're isolated or centered out, or setting criteria based upon for hiring based upon those 11 prohibited grounds. It is 2:15. Let's try to get out of here early today. Let's set time for our break now. We usually break at 2:30. So let's take a 10-minute break, come back at 2:25, because the goal is to try to get finished about 5 or 10 minutes early today. So please do not leave the room. Just stay muted and your camera off, and come back to us at 2:25, and we'll now move into the interesting area of diversity, equity, and inclusion. So we'll see you in 10. Thanks. Back. Thanks a lot for the quick break there, guys. I hope everyone got to answer their calls and do their thing. We're going to hustle now through the principles of diversity, equity, and employment equity. But before we get started, is there anyone that wants to unmute their phone and jump in, or phone, their computer, and jump in and ask any specific questions about the human rights section that we just covered? Okay, just reminding you that if at any point in time during the presentation you want to ask a specific question, the group size is really pretty reasonable, and just unmute your microphone and jump in and say, "Hey, Steve, can I ask a question?" Of course you can. We'll try to deal with it right then and there. Okay, so moving along, we hear a lot about diversity, equity, um, in the news. It's pretty topical in United States right now. And for some reason, this diversity, equity, employment equity. Okay, so we're going to talk a little. It's pretty topical in the United States right now, and a little out of context for Canadians, really, quite honestly. And so when you hear the DEI acronyms kicked around by the current executive branch in the United States, and some of their threats against universities and against businesses and suppliers for having DEI policies, the best I can say is my interpretation is that it's not really the same. I think the allegations in the US that are not applicable to here in Canada is that the allegation in the United States is that DEI and employment equity has morphed into quota systems and unfair, they would call them, allege that they're unfair hiring practices, and they're accusing institutions of, in effect, discriminated against people who are not covered by the 11 prohibited grounds, and giving an unfair advantage to people who fit into those categories. And that is certainly, I don't know that that's true. I don't think that that's true. Certainly don't think that was the intention of DEI policies and practices in the United States. But the important thing is that we don't misinterpret what happens in the general media for the US and apply it to Canada and the way that we use the terminology here, because they're different. It is really clear that our employment equity legislation in Canada, which is federal legislation that only applies to federally regulated companies and organizations, and to federal contractors, and we'll get into the federal contractors portion of it, is designed to deal with women and people with disabilities and Aboriginal people. So first off, it isn't all 11 categories that are covered under the previous legislation that we were talking about. It is really specific only for women, people with disabilities, and Aboriginal people, and for visible minorities. And visible minorities is very loosely defined, and it's designed to not create an unfair advantage for any people that fall into those groups. It is intended for people to take a look at so it's not quotas. It's definitely not quotas. It's designed to achieve equality in the workplace so that no person shall be denied employment opportunities or benefits for reasons unrelated to their ability. And so it's thinking there may be some unwitting or unknowing systemic discriminatory practices that they're not even aware of in them. And so let's make a conscious effort to make sure that we make sure those opportunities are available to groups that are not represented in our employment group. And so if there were any disadvantages that occurred in the past to women, Aboriginal people, people with disabilities, and groups of visible minorities, that we are basically saying we're we're going to make policies and practice and take special measures to let them know that those opportunities exist and that they have an opportunity to apply. So provincially regulated employers in Canada don't apply to this legislation, except for if you're a contractor to the federal government. So basically, it says this. Let's take a look at the demographics of the community that we employ people from, so in the geographical area of our workplace, and say, well, what percentage are Aboriginals and what percentage are women and what percentage are people with disabilities and what percentage are visible minorities. And so, and by the way, some of those groups overlap with each other, and say, okay, so let's take a look at our workforce and just ask ourselves, is our workforce representative of the community that we work in? And if it's not representative of the community that we work in, we got to ask ourselves the question, why? Is there something about how we advertise or how we hire or how we evaluate or how we create a work environment for people that makes them feel as though they're included and that they might apply to work for our company? And the general principle is this. It's not that we need to correct the wrongs of the past, or that we need to create that we've got a quota system that we must adhere to, and we have to hit a certain number by a particular point in time. The concept is that if you recruit from and you are aware of the candidates that come from 100% of the community that you work in, then you've got the chance of hiring the best people. And if by any chance we don't make certain groups aware of the employment we have, or we don't create an environment that they feel welcome into, and some people don't try to work for us or want to work for us, or we've got some barriers that exist that prohibit them from getting access to those jobs, then we're not doing our company or our customer or our potential workforce any favors whatsoever. So it doesn't say what you must do or who you must hire. It says be aware of the demographics of your community and be aware of your the demographics of your workforce and analyze it and review it frequently, once a year, and make some policy decisions that might address the imbalance between the community and your workforce. And you get measured on whether or not, judged, I guess, by whether or not you actually do the things you say you're going to do. Not that you hire a quota of people that you say you're going to quota hire, because you never make a promise of a quota hiring. You analyze the demographics of your workforce, you analyze the demographics of your community, and you look at your policies, practices, and procedures and say, these are the changes I'm going to make to my policies, practices, and procedures. And you get judged based upon your ability, you get judged by your employees, by your community, as to whether or not you fulfilled your promises in those areas. So the federal government comes along and says, hey, look, if you're going to be a big supplier to us, and particularly if you're a staffing company, and you're going to have hundreds or thousands of people working in the government, then we want you to adhere to the same employment equity standards that we do. Now, this also happens, for example, for federal, yeah, I had one customer once, for many years. There was a massive supplier of medical equipment and medical products and things related to food safety and medical safety. And those things are those particular things were federally regulated, and the federal government bought a lot of those things. And so this provincially regulated company, in order to adhere to federal employment equity, needed to prove to their customer, the federal government, that they did something similar to what the federal government does for their own workforce. And so it goes like this. You register as a vendor of the federal government, you're of a particular size, and you say, okay, I'm big enough that this applies to me. And then you conduct a workforce analysis. So let's take a look at the data in our community. You conduct an employment systems review. So you take a look at all of your systems, processes. What food do we serve? Where do we advertise? What hours of work do we have? How do our schedules work? You created an employment equity plan. They say these are the things that we could possibly change and make better over time to make our workforce more accessible to a larger group of people. You establish and sustain the employment equity program by, having people that do certain things, and you submit an annual report to the federal government saying, this is what happened in our first 4 steps. At the end of the day, as far as I know, companies are basically judged on by the federal government on whether or not you submitted the plan, or you submitted the report. And then they don't make any further judgment beyond that. But the reason why it's there is because if a person comes along and says, hey, I don't think these guys are doing what they say they're going to do, then there's an opportunity to make a complaint so that you're not just submitting a plan and doing nothing. So, so it really becomes sort of forward thinking, causes employers to be aware, to forward think about the things that they could do differently, to say the things they're going to do differently, to put practices and policies in place to try to do those things differently, and to make them available to their workforce and to the community and the government to take a look at them and say, hey, are you doing what you said you're going to do? And so really, a company could only be found at fault for making a plan that they didn't follow through on, or made no effort to follow through on. And so it's pretty low key with some high level, lofty goals and objectives to create a workplace that is more equitable for people to apply to work within. And so the employment equity involves, employment equity involves identifications of systemic barriers, and it does not involve B, government imposed quotas. It involves plans to overcome the barriers that are identified in A. It puts in place a requirement for companies to reasonably accommodate the groups in the 4 areas, and to be proactive in looking forward and planning ahead. So it's pretty wide scope. Now, so this is nothing like the kinds of things that the President of the United States, for example, is accusing Harvard University of, and whether or not his accusations are actually accurate or truthful or not is a different story entirely. But basically, it does not involve quotas, and it does not involve unfair hiring practices towards particular groups that were allegedly discriminated against in the past in order to make things right in the future. It's about looking at the systems and the process to make sure that they're good. So, some of the things that are affecting some changes in our workforce have to do with the large number of baby boomers approaching retirement age. And so I'm considered, for example, at the last edge of the baby boom. I think that when I was young, I wasn't considered a baby boomer, and then they kind of expanded the years a little bit as they sort of created these sort of categories. So I would be considered one of the last years of baby boom, and definitely approaching the early ages of retirement. And so turning 65, in the coming year. So there's lots of people my age and a little bit older, probably the biggest bulge in terms of demographics in the Canadian economy. So yeah, so are these people are these people going to work longer, stay employed, or are they going to retire and create a massive shortage of people in the workforce? If they do retire, is there going to be an excessive burden on the economy with respect to healthcare and contributions to Canada Pension Plan and deductions from Canada Pension Plan? How is this going to change the world in which we work? And Canada has entered, I think our fertility rate is about 1.6 right now. And demographers will tell us that you need a fertility rate of 2.1 children in the lifetime of Canadian females in order to sustain our population at an equal level. And so since our population fertility rate is 1.6, we're below we're below the level that is required just in order to have future people in our workforce that are going to be around to pay for the people who are retired. And so immigration becomes an absolute necessity in order for us to keep that number at 2.1. In order to keep our population at least at level so that it doesn't decline. And so that as our economy grows, and we do have growth in the economy, 3, 4% a year, that we need to have people at the rate of 3, 4% a year in order to do the work that is necessary for the growing economy, assuming that we don't become more efficient and need less people in order to do the work. And then, of course, you throw in things like AI and how that's going to affect our ability to perform work and who's going to perform work. And all of these questions start to lead into, are we accessing 100% of the available workforce? Are we set up to be able to employ immigrants? Are we set up and a different demographic of immigrants, maybe coming from different countries than our immigrants came from, with different backgrounds in education and languages and cultural expectations and religions than we had in the past? And are we able to accommodate an aging workforce? And do we have the equipment and the accessibility and the chairs and the work hours and the requirements in our work to deal with an aging workforce? Because the goal and objective is to, from a business perspective, is to be able to say, we want to, one, have the demographics and the distribution of workers in our workforce that represent the communities that we serve and the customers that we serve. Doesn't make any sense to operate a bank branch without any people that speak the languages of the customers who walk into the branch, or to operate a grocery store of people who are serving the customers in the grocery store who don't speak the language, understand the cultural expectations, and even the food, the cultural expectations of the food, of the age of the people, and the religions of the people, and the ethnicity of the people who buy food in our grocery store. And so having people who understand these things and are able to serve our customers, make us a better vendor, improves our retention of employees. We need to attract a broader distribution of people into our workforce in order to better serve the customers that we have, so that we can keep our costs at a minimum and our profitability at a maximum, to maximize the benefit of the opportunity that is available to us. So from a business perspective, DEI, employment equity, and removing discrimination from our workforce is darn good for business. And then there's the ethical question of the Canadian Constitution. Are we serving the values that the Charter, that Canadians believe in? And so, one, are we doing the right thing because it's right? And as an incentive. Let's do the right thing, not only because it's right, because it's profitable, because it makes darn good sense. And it doesn't make a lot of sense to do the wrong things, because the wrong things often are only profitable, if they are profitable at all, in the very short term, in the very short view, and they undermine the profitability and the sustainability of the business over the course of the long term. Now, Ontario's got a very specific legislation that doesn't exist in other provinces, but it's called Accessibility for Ontarians with Disability Act, and it's been around since 2005. And the whole objective was that by last year, all of the modules of OADA were put into place. And so it was a long-term 20-year goal. And the first things first, the customer service modules, required employers to provide education to and information to their employees so that they understood how to identify people with disabilities and how to accommodate people with disabilities and how to serve people with various disabilities and how to recognize what a disability and understand what a disability was. And then the second phase was for us to create information for the community and for our employees and to communicate our understanding and our policies and our practices for people with disabilities, and then to change the way that we employed people, everything from the tools that we use and the hiring methods that we use and accessibility to the properties that we work within. And then finally, it became really, I got to the two big ones. This is why it was stretched out over 20 years, was transportation. So you might have noticed, for example, the buses, not every bus, but maybe one out of every 4 or 1 out of every 5 buses that come along is a leaner tilter bus. I have a daughter with a disability. She's in a wheelchair. She's 31 years old. She's been in a wheelchair all of her life. And the first time that we experienced a leaner tilter bus was in Disney World, like 15 years ago. And when it came around to the Disney property that we were staying at, the bus stopped, lowered itself, tilted a little bit up on edge, and out came a ramp so that her wheelchair could roll right onto a ramp. Then it lifted her up into the thing that came back. And then there were spots in the floor where you could just roll up to and hook the straps on and put it in there, so that it was a regular old bus that was not very regular old bus at all. It was made to accommodate people with walkers and wheelchairs and other mobility issues. And, to bring this even further, so at some point in time in her life, she relied more so on wheel trans help, it's called in our area, but it's wheel trans. And, you get registered and you qualify and you phone and you book your wheelchair to come and pick you up and take you to school or take you to the mall or to your doctor's appointments or to work. And you pay pretty much similar to what a able-bodied person might pay to go on the general transportation system. But these ones are designed for people with mobility and other disabilities that would prohibit them from using the general transportation system, the public transportation system. And then along came stage 4, and we live in Mississauga. The city of Mississauga said, hey, you're no longer eligible to have Wheel-Trans come to your door, because if you go down there, we've got a bus that will tilt and lean, and you can take your wheelchair on. Now, in my daughter's case, we had to appeal that decision because we have no sidewalks in our neighborhood, and it's 1.5 kilometers, almost 2 kilometers from the closest bus stop, and she has a manual wheelchair, so she can't get to that bus stop usually from about November to April. And so they provided reasonable accommodation, and they said, okay, she's going to be eligible for Wheel-Trans to come to the house to pick her up if you book it and do all the normal things and pay. In the months of November to April, and she's going to be required to use public transportation system from May until October. And so there was a perfect example of how AODA 1 was designed to provide accessibility to Ontarians with a disability. Number 2, we got to the 4th stage where the municipalities were required to provide a broader level of transportation to people with disabilities, and they did. And then going back to the issues of discrimination under the legislation, that they provided a reasonable accommodation for her because it was unreasonable for her to get to the place that they had requested that she roll to. So then finally in stage 5, you've seen this everywhere except for older buildings of a particular age, or heritage buildings, that built accommodations were required to put in things like wheelchair ramps, accessibility, braille on their elevators, ways to communicate things that are on signs so that they can listen to things that are on signs, and go to listening stations and all kinds of things in the built environment, so that elevators, ramps, wheelchair lifts, and things for accessibility in the wheelchair environment. So they gave companies 20 years to try to figure out how to do that. And the reason for this is because, 1 in 7 Ontarians has a defined disability. 95% of those 1 in 7, more than 6 out of 7, almost all of them, their disability is hidden. That you wouldn't know that there's a prosthetic or a cognitive disability or a vision disability or a hearing disability, that you wouldn't know that just by simply observing a person. And so we needed to not only create an environment through OADA and in other provinces, other legislation and similar good faith reasons, to realize that probably 1 in 7, 1 in 6 of the people who walk through the doors, we need to accommodate them in some particular way. It's estimated that 1 in 5 Ontarians will be 65 or older by now. And so I should update that and get the exact number. How many people are 65 or older? So 20% of our population falls into the aged demographic that I talked about earlier. More than 500,000 Canadian adults have some form of vision loss that's not corrected by glasses, and more than 1 million live with some sort of hearing loss. I think the number's higher than that. I think these things have caused some greater incidence of hearing disabilities. And really important is this cognitive and mental illness that come with every name that you can think of, from Alzheimer's, dementia, schizophrenia, ADHD, post-traumatic stress disorder, anxiety, depression. The lists and the names of the definitions of cognitive and mental illnesses is, quite frankly, unlimited, and entirely unobservable or hidden to the general public. So the question is, do we have systems and processes in place to deal with these issues, with people's fear of entering, people with autism having fear of walking through thresholds? A really common thing with kids and people with autism, that moving from outside to inside through a doorway or a threshold. And what have we done to accommodate that? Are we creating these bottlenecks where there's just like constantly unsafe? Do doors for people with wheelchairs and in the village, a part of Mississauga that I live in, in the older areas, the stores and restaurants, the doors swing open into the sidewalk. And so if you're moving along at any pace close to a door, way in Port Credit in Mississauga, and a person opens a doorway, there's a really good chance that a person in a wheelchair is going to slam into them, and so as they're moving along. So do we look at our physical environment in a way that one attracts our customers and accommodates our customers so that we can maximize the business that we do, that attracts 100% of the available workforce so that we can hire the best people that are available in the workforce to work in our business. And even more so, once we've hired and trained these people, have we found ways to keep them working for us so that we retain our employees and gain the advantages that we hope and want to expect from having those people work in our workplace. So, what is considered to be a disability? It can be any form of physical disability, infirmity, malformation, or disconfiguration. It can be conditions of mental impairment and developmental delays, and developmental disabilities. It can be learning disabilities, any form of mental disorder. Bell Days, I think, were a wonderful opportunity for people, for famous people, athletes, to speak about their disorders, their anxiety disorders, their physical disabilities, to kind of make it more people more aware of what's going on around them, any injuries which may have occurred in the past. And so every company in Ontario, and I think that just as a matter of policy, companies across the country should have some form of policy statement that helps to establish the culture of an organization, and to make it part of their policies and practices. The organizations. So here's an example of a policy. Our organization, our company, is committed to providing exceptional and accessible services for our customers. Our services will be provided in a manner that respects the dignity and independence of all of our customers. The provision of services to people with disabilities will be integrated whenever possible, and persons with disabilities will be given an opportunity equal to that given to others to obtain or use the benefits of our services. I think it should say including employment in our organization, or provided by our organization, or provided on behalf of our organization. So I think every company, first off, legally in Ontario, every company needs to have a policy like this in place. And I think outside of the province, it's just a darn good business practice. So it requires, the policies require accessibility training, use of assistive devices and animals and support people, and notices of temporary disruptions of things like elevators and escalators and technology. Most companies should have a process for feedback so people can provide a complaint to you or give feedback to you saying, hey, this is really difficult for me to do this because of my disability, so that corporations and organizations can improve the way that they do business with people with disability. And they should provide notice to people on how they can get different formats. Can they listen to our policies on our website? Can they read about this using Braille? Are there larger font prints that people can use it? Now we get into this DEI, the generic terms of diversity, equity, and inclusion. And we hear about how it's used, or I think misused, in the United States. And really, instead of being influenced by the rhetoric that you might hear about or read about in the news south of the border, where, again, they interpret DEI differently, think about it in Canada, where companies that are diverse and equitable and inclusive, because they're better able to respond to the challenges of their customers, they're better able to win and attract top talent, that they're better able to meet the needs of a more diverse and broader customer base, more customers to our business. So with DEI in mind, Canadian employers must consider how to better support their employees more than ever, with a focus on attracting and motivating and retaining a diverse workforce. And I continue to use the expression to be able to hire and have access to 100% of the workforce. So when choosing, they are choosing from the best, not limited from their silo that they might be limited to because of some policies that aren't really truly DEI intensive and extensive. So when we talk about diversity, we think about gender diversity, what makes the composition of men and women and non-binary people in the population and in our workforce. Age diversity, or people in a group that are most likely from one generation. You know, there was a point in time when I thought that I was really doing this well, and then realized that, like, this goes back to late 90s, I think. And like an unusual percentage of of my workforce, of the important workforce, of managers and branch managers, were off on maternity leave. And it became quite evident to me at that point in time, two things, one positive and one not so positive. The positive thing was that, took great pride in this, that we had created a workforce where people felt comfortable and confident in their work stability. So much comfort and confidence that they weren't delaying having children, that they felt financially stable in their family life because of the jobs and the careers that we had made available to them, that they could support a family and they wanted to have a family, and that they felt also comfortable and confident that they could take advantage of the benefits that we offered and then come back to work for us again. And nearly, I can only think of one incident, quite frankly, in all of those years that one person didn't come back to work for us again. And it was because the new mom got pregnant again before she came back, and they moved away. And so, you know, so a lot to take pride in the environment that we had created that was supportive of families and people and their personal goals, wants, desires in life. But the other thing was, I realized, man, the vast majority of my managers were at in an age bracket that were childbearing age. And why weren't they? I can understand why they maybe weren't younger, because they hadn't, in their early 20s, hadn't developed enough experience and climbed through the ranks in order to get to the management level. But we didn't have a lot of older managers. And so that became sort of a trigger for us to take a look at the age diversity of our workforce. And we started hiring people from a more diverse group of people. And it wasn't to discriminate against age-bearing women. It was that we became aware of ourselves that we didn't have a lot of people that were in their 50s and 60s working in our organization. And so we hired more salespeople and more supervisors and more safety people and more people we made a conscious effort to be more diverse in our age diversity in our hiring. Ethnic diversity. Do people in a group share common national or cultural traditions? And do they represent the different backgrounds of people in the customers that we serve? And do we provide the types of policies that are needed to represent the religions and the cultures and the family values that they have? And we made every effort to do that, and we should all be trying to do that. And then, of course, physical disabilities. This is something, because I have a 31-year-old disabled daughter. This is something that I have always personally been acutely aware of, creating an environment that is physically accessible to people. And of course, AODA has created legislation that requires us to create physical disabilities. But I just want to put this to you. While this week, this week, the Paralympics are on, and we're watching, for example, downhill skiers take a mountain and the gravity and the slope of the mountain to do something extraordinary, to get into a sit ski or to be on one leg or to ski with prosthetics and use the force of a mountain and gravity to do something extraordinary, to bring thrill and excitement into their life, to do things that are well beyond what any able-bodied person could ever imagine doing it, traveling at the speeds and with the skill that they do. And so a mountain can be an opportunity. But a 2-inch threshold, a curb on the side of the road, a step into a physical work environment can be absolutely prohibitive to a person with disabilities, and particularly to a person in a wheelchair. And so we sometimes look at things like the Paralympics and we think, oh, isn't it wonderful, the things that people with disabilities can accomplish now? And we minimize the issues of things like thresholds, tiny little steps, 2-inch step. Can't get our wheelchair over a curb, one step into a workplace. So we need to look at our physical workspace in every aspect, besides the shape of our desk, the keyboards that we use, the equipment that we type on, the things that we read, the thresholds that we roll over to get to our workplaces, and have to ask ourselves, are we creating a workplace that is inclusive and inviting to 100% of the available people that could work for us? Equity refers, when we talk about diversity, equity, and equality, equity refers to the fairness of the way that we treat people, so that norms, practices, and policies in place ensure that it's not predictive of the workforce. So equity differs from equality in a subtle but important way. Equality assumes that all people should be treated the same, and equity takes into consideration that people are different, so it creates an opportunity for people to get the same outcome or the same end result. So equality is treating everybody exactly the same, and equity is creating. So golf, for example, the whole handicap system is about equity, because it means that a person who's a 10 handicap, a person who's a slightly better than average, but not much better than average, a 20 handicap, which is a not most skilled golfer in the world, and a pro golfer who's a 0 handicap, that we put them all together on the same golf course, and we create a set of rules so that if they played their best, because the whole concept of golf is that if you play better than you normally play, then you've got a chance of winning. And so golf is designed, when we play handicap golf in amateur golf, is designed so that the high handicapper, if they play better than they normally would play, and then a medium handicapper played even more better than they normally would play, and the low handicapper played the way they normally would play, that we're actually measuring the winner by how better they play. The game is designed that the winner is the person who plays the most best compared to their average game of golf. So it's not about who got to look. So the game of handicap golf is designed to create a winner of the person who plays the most best compared to the way that they would normally play. So it's like the ultimate in terms of equity. It's not equal. Those golfers did not golf equal. The best golfer golfed the best. The second best golfer golfed maybe the second best, and the third best golfer golfed the third best. But handicap golf is designed in a particular way so that it creates equity, not equality. And in the workforce, we take a look at it and say, can a person perform better if can a person get access? Can they read Can they read the same as I read by making a larger print? Now it's equitable. How you understand and use that information differently by different people makes the difference between all of us. But the fact that we were all at least able to read it makes it equitable. So creating an environment that creates equity allows people to achieve their maximum potential. So they're not equal, but we've created an equity environment. Inclusion refers to a workforce experience that the workforce differs to the degree that it embraces all employees and it allows every employee, regardless of their age or their background or their ability or their disability, to make a contribution. So it's not a law. When we create an inclusive environment, we say, hey, what's your opinion? What do you think? And so hidden behind that is, hey, you're older. You've got some mobility issues. You don't walk as fast as the rest of us. We're not saying this out loud. We're saying, but you know what? What do you think about how this works? Or in a different conversation, it's like, hey, we want everybody here to be healthy. And we've got this air conditioning and this open window or closed window or air policy or whatever. And some people wear perfumes and there's smell from the photocopier and things. And we might say to the person who's got allergies, hey, what do you think? Don't go single about it. You have allergies. What do you think? Say, we say to everyone, what's your opinion? What do you think? How can this work better for you? How would you recommend that we do this? What makes this a better workplace for you? Does this place make you feel safe? Does it make you feel happy? Are you engaged? Do you share in the importance of what we do? Do you have this, what I call the compelling future focus? Does it allow all of the people to feel compelled to come together, to believe in the things that we believe in, to make the things we make and do the things we do on behalf of the customers, in the difference in the lives and their businesses that we make, that we serve? Do we all share in that? And did we ask everyone? Everyone of every ability, of every age, of every culture? Of every ability and disability, did we ask them, do you share and do you have an opinion? And when you create an inclusive environment where people feel that they can express their voice and be heard, whether or not we actually do what they say or not is a different story, because it might be a ridiculous recommendation. It might be too expensive, or it might not even be valid. But people in an inclusive environment, when we talk about DEI and we talk about inclusion, all we're saying is, do people feel comfortable in participating? That's all we're saying. It's not a nefarious thing that the Donald Trump is trying to scare people away from. DEI so bad. In Canada, it's simply, the I simply means, do people feel comfortable in participating? That's all it means. And the E only means, did we create an environment, not an environment that is equal for everyone, but an environment that people feel like they've got equal opportunity to get the result that they want? That's all that it means. So DEI is not a dirty word in Canada. Feel comfortable and confident in using the words DEI to say we've created an environment that is DEI, that has got diversity and equity and inclusion for everyone, so that we can be and hire from the 100%, not a siloed percent of the world that we live in, and that we can serve 100% of the customers, not a siloed group of our customers, and then we create an environment that people can thrive and be the best they possibly can be in. So today we talked about human rights legislation, federal and provincial. Yesterday we talked about employment standards legislation and some of the areas of equity that were included in that. Today we talked about the federal government employment equity legislation and how that all federally regulated companies, not staffing companies, are required to participate in, unless you're a federal contractor and you participate in the federal employment equity legislation, contractors legislation. And we talked about AODA, Access for Ontarians with Disability Act, and if you're not from Ontario, about how the principles of that can apply to you. In our last section, the next 40 minutes or so, 30 minutes or so, is going to be on privacy legislation. And PPIDA, which is the acronym that you often hear, refers to the Personal Information Protection and Electronic Documents Act. And it deals with the information that we're allowed to collect, how we collect it, what we do with it once we have it, and a person's access to their own information and how they can affect it. So the Personal Information Protection and Electronic Documents Act, PIDA, protects personal information in the hands of private sector organizations and accompanies this with guidelines for the collection, the use, and the disclosure of that information. PIDA legislation particularly applies to federally regulated companies and governments. And as a result of that federal legislation and regulation, the provinces have expanded it to apply to themselves, the province, and how the government, each provincial government, collects and uses the information, and to municipalities, which is another level of government legislated by the provinces. In many provinces, like Ontario, they've also extended it so that it does apply to people like you and I in the private sector for provincially regulated companies if it has to do with health information. And so we often think about banks federally regulated, so they've got some information, high-level information protection requirements because they're federally regulated and they fall under the Federal PIDA Act. We often think about the government as we're providing information on tax returns and filling out forms and doing things that they've got an obligation to protect us, to protect our information. And then finally, in most provinces, and particularly in Ontario, where most people on the call are from, they've extended that to provincially regulated organizations with respect to the collection and use of personal health information. So the Privacy Act does not apply to the resumes that you have. I mean, hey, look, keep your information private. It's business practice. You could get sued under civil laws for other things, but as the Privacy Act goes, you need to protect the information that is particularly related to a person's health information. So, for example, like their health card number and anything that they might have about their disabilities or about their health benefits. So PIDA applies to private sector organizations across Canada that collect, use, or disclose personal information in the course of their commercial activity. And the law defines a commercial activity as any particular transaction, act, or conduct, or any regular course of conduct that is of a commercial character, including the selling, bartering, leasing of information in their business. So these provincial laws, for example, in British Columbia and Alberta and Quebec, they have their own private sector privacy laws that have been deemed pretty much the same as the federal laws. So Ontario hasn't done that. But Ontario, British Columbia, and Quebec have gone ahead and said, okay, we're going to take this privacy legislation that exists for the federally regulated companies, and we're going to write our own. And for all intents and purposes, they took almost word for word and rewrote it with the words Alberta or Quebec or British Columbia in it, so that their provincial PIPEDA legislation applied to provincially regulated companies like you. If you're in Ontario, they didn't do that. Organizations subject to substantially similar provincial laws are exempt from federal PIPEDA if you're in different provinces. And then other than the three above. And then provinces like Ontario, New Brunswick, Nova Scotia, Newfoundland, and Labrador have adopted substantially similar legislation for, as I mentioned, for health. So in Ontario, the Information and Privacy Commissioner of Ontario enforces HIPAA, the Freedom of Information and Protection Privacy Act. So this has to do with the government. And they've put their emphasis on the Freedom of Information Act, on the government's collection of information, where people, individuals, companies, and organizations have the right to ask for information in the government. So they kind of put a flip on it, and they said, okay, the government's going to do certain things, and people are going to get paid a certain amount of money, for example, and you can access that information through the Freedom of Information Act. So the government's got an obligation to protect certain information, and the government's got an obligation to provide the freedom or access to information. So, so that has to do with provincial government. Then they created the Municipal Freedom of Information Protection Act, and they said, okay, you municipalities, you got the same thing. You're going to have to protect, your people's information so that people can't log on and look on the internet about the information you've collected about people in the past. Got to protect certain information, but you also are going to have to provide freedom of information, and things like how much money did you spend, what vendors did you buy from, how was that decision made, their minutes of and recorded municipal, city hall meetings, that kind of stuff. And then they created FIPA, which is pronounced the same as the municipality freedom. And this has to do with personal health information. So this requires doctors, hospitals, home care companies, pharmacists, anyone who's collecting and using personal health information. They've basically said in Ontario, kind of like the federal government where you have to protect information. If you're in Ontario and the information you're collecting is health related, you're going to have to protect it also. So you don't have to necessarily be in a health industry. You have to be in an industry where you collect health information. So that might have to deal with people's disabilities when they're applying for jobs, when they apply with you, or for their health benefits through your health benefit plan in your organization. It could be considered health information, and so therefore it has to be protected. So what are the 10 principles of all of these laws? One is that organizations need to be accountable for their use of the information, the collection of their information. They need to, it needs to be legit in the way that they describe it, in the way that they write about it, in the way that they put it into their policies, and they need to be held accountable for doing all the things that they say they're going to do. Here's the important part about it. If you're collecting personal private information, you have to identify why you're collecting it. So let's say, for example, we were required to, we were legislated eventually for employment agencies. We would have to say, We're collecting your resume and all the information in it, the personal and private information in it, including your date, maybe your date of birth and your place of where you live. And we collected your SIN number and others, and we got your health card number to put in our health benefits plan or whatever for the purposes of employment. And that this information that we're going to use is only going to be used for the purposes of employment, either working in our organization or for us to help you find employment in one of our customer organizations. And that we won't be selling your information to a credit card company or selling it to a survey company or using it to try to figure out whether or not we should be getting you to join a political party or selling you something else like training and education. If we identify the purpose of which the information is being collected, then we ask for consent from the person. Do you agree to allow us to keep this information? And we'll talk a little bit about consent in a future slide. And we limit the collection of information to just the categories of which we're going to be, the purpose is. So if we're going to say, hey, we need to collect this information from you, and we need to know your date of birth so that we can put you on our benefits program. Certain things stop and start at different ages. That we'll never use that date of birth for any other purpose other than the purpose of which it was intended to. So we have to limit its use to just the purpose that it was used for. We have to disclose it to only those ways that you've given us consent to disclose it. And we have to retain it and keep it in a way that keeps it private and confidential. We've got some degree of obligation to ensure that the information that we do have on file and that we retain on file remains accurate. That if something changes in your life, that we've got a mechanism in place to update it. We have to provide safety safeguards about that information. And then openness, my goodness, you get notifications from federally regulated and from health-related organizations provincially, and in Alberta and British Columbia and Quebec, for the provinces that do have PPIDA legislation, you're going to get a notification that says, hey, our system has been breached on such and such a date, such hackers got into our system, and we believe that they got this information. So change your password, or we're doing everything to recover the data, or we've fired that vendor and we're getting a new vendor because it can't be fixed. So they've got an obligation to safeguard it, but they've also got an obligation to be open with you about what's happened to that information. So theoretically, for example, in Ontario, if a nurse comes to your house and fills out a form on her tablet, and she's going to save that tablet until she gets to Wi-Fi or the office or something, and then it uploads, and then she lost her tablet, then the openness requirement would require your PPIDA policy to say what the policies and practices are for now that you've lost a tablet that contains somebody's private information, and the openness portion of it requires them to tell you that they lost the tablet on the date that they lost it and what potentially might be vulnerable in terms of information. So PPIDA information needs to be accurate, needs to be safeguarded, there needs to be firewalls and password protections and all that kind of stuff. And quite honestly, health data in Canada needs to be saved on a Canadian server. They won't even allow under PPIDA legislation and PPIDA legislation for federally regulated organizations to have the server saved on a foreign server. So you can't just have it in Google email and saved on a US based server or something like that, or be using TikTok on a Chinese server that needs to be saved on a Canadian server because there's specific laws about what kind of security must be on that Canadian server that they can't obviously enforce if it's saved on a European or an Asian or an American server. People need to have individual access to their own information. They can say, hey, what information do you have about me, and is it accurate, and is it updated, and do I want it there anymore? So if they're no longer a customer of yours, then can they have that information removed from your server? And there needs to be a process in place that you document so that people can challenge your compliance. So, what's considered personal information? So from the federal legislation standpoint, and in the provinces where they've pretty much copycatted their own PIPEDA legislation, your age, your name, your ID number, such as your SIN or your health card number, your income, your ethnic origin, your blood type, your religion, these are all considered personal information. Any opinions that you might have expressed or held and given by filling out comments, forms, and things, and your social status, whether you belong to a particular social group or you're married or family, those are all considered to be private information. Any of your files with respect to your credit information, your loans, that's private. Of course, your medical records. If you've had disputes in the past and you've appealed things with your employer, that needs to be considered private. Your intentions. For example, if you intend to change a job, you applied for another job inside the company, but maybe didn't get it. If you made a human rights complaint, those things are all considered private and must be protected so that they're not shared to be used in a manner of which it was not intended when the information was collected in the first place. So the question is, your province has adopted another privacy legislation, therefore PIPEDA does not apply within that province. Well, if you're a provincially regulated company and your province has adopted its own PIPEDA legislation, then the federal legislation does not apply to you anyways, but the provincial legislation does. If you're in a province that, like Manitoba, I think, for example, that has not created its own provincial PIPEDA legislation, and you're not federally regulated, you're a staffing company, then the legislation doesn't apply to you. It doesn't mean that you shouldn't be looking at the legislation and putting policies, practices, and procedures in place to ensure that you are protecting your customers and your employees' privacy. You should be doing that out of a matter of good practice, but there isn't specific legislation if you're in one of the provinces that hasn't put it in place and you're provincially regulated. One of these things doesn't belong. Which of the following statements about consent is false? Or I haven't really talked to you about consent, so we'll talk about it now. Organizations can generally rely upon implied consent when the information is likely to be considered sensitive. The answer is no. You can't assume that because a person gave you information or disclosed some information in an interview that you've got consent to use and store that information. Can't just assume that. But the mechanism for consent chosen should be clear and unambiguous. So you can say, you've done this before. You've been on a call where you're answering questions about something. And then a person says, hey, we need to get your consent for this. So we're going to use our consent system. You're going to hear a beep. And there's going to be 3 questions. You need to answer yes or no to the questions. And then when it's over, that consent is going to be saved, and then we can go forward to the next question. And also it goes beep. Do you understand that this company, yes. Do you understand that the information that you're going to be providing is going to be used for the purpose of which it was only intended for, which is to facilitate a loan and your access to the loan? Yes. Do you understand that we will make every effort and you have the right to access the information and change it? Yes. Perfect. Bang. Done. Then all of a sudden the customer service rep comes back on the line, goes, thank you very much for providing unambiguous and clear consent through a mechanism that you understood. And then they go on asking you the questions and you get your bank loan. Consent can be achieved in a number of ways. It can be done in person. It can be done by phone. It can be done by clicking a box over the internet. It can be, you got consent every time you add an app or do something, or you join Google or Facebook, something comes up and says, have you read all of this? And do you consent to something? And you click on it. And so, the lawyers fight over whether or not when you read the 20-page complicated document and you clicked consent at the end, whether you actually did consent or not. But the method of consenting can be multiple, and it just needs to be clear and unambiguous that you're giving consent. The legislation also has a process for complaint, and it really is a complaint-based piece of legislation. So in other words, you write a privacy policy, you document your privacy policy, you ask for consent, you've got a privacy officer, you go ahead and you do all the things, you collect information, you use the information. Nothing happens. There are no privacy cops. They don't come and knock on your door and say, it's your turn to be randomly selected to review your policies, your privacy policies. It is entirely complaint driven. So if you have a complaint about privacy, then first off, you look to see, is the organization federally or provincially covered by provincial legislation, or are they federally regulated and so it's covered by PIPEDA, or are they provincially regulated and they operate in the province that has got PIPEDA, or is it in Ontario and is it a municipal government or a provincial government organization, or is it in Ontario and it's private health organization, health information? So first off, is there legislation that applies to my circumstances? And secondly, you ask the question, does this company have a privacy policy? Can I read it? And you read the policy, and then do they have a privacy officer? And the individual makes a complaint to the privacy officer through the policies that were clearly documented in the privacy policy. If by any chance a person feels like their privacy complaint was not addressed in accordance with the policy properly and resolved, or if the person feels like the privacy policy is not compliant with the legislation, then a person goes to the Privacy Commissioner of Canada or of their province and makes a complaint and says, I've got a problem with this hospital or with this company. They don't have a policy. So my complaint is that they don't have a policy and they've got my private information. Or they do have a policy and they didn't adhere to their policy, and I've got an issue with my privacy of my information. And then it goes to an early resolution officer who then works between the complainant and the organization to help them put it in place. It is very rare that the privacy commissioner will take a company to court and sue them, although it could happen. So if it turns out that the organization knowing, wittingly, and intentionally failed to have a privacy policy in accordance to the legislation, and they refuse to follow through on doing it when instructed to do so, then they could go to court and they could be fined. Or if they knowingly and wittingly violated their policy, for example, collected the information about your blood and then sold your information to some blood guy or to some bank or some insurance company or something like that, and used the information in a manner for which it wasn't intended, and the early resolution officer says, boy, this is super egregious, or they're not willing to comply, stop doing it and fix it and make people whole, then there could be legal, but almost entirely It's very rare to hear of somebody going to court because they absolutely refuse to follow the legislation or to try to follow the legislation or do their best, make their best effort. So we get into these issues of social media. Don't worry about COVID-19. We get into these issues with social media where privacy becomes an issue all the time. And the question is, you know, um, are you giving people a phone and a laptop, and are they using your company equipment in order to participate in social media? And are they disclosing private information in social media? Have they set up their security in such a way, or are they posting things in the public domain that are violating your policies and practices? And all I can say is this: like, we could do a full 3 hour full session on best practices with respect to social media. But the answer really is, have a policy, write it down, be inclusive in the creation of your policy that you go to your policy and play. What do you think? What do you think we should be doing? What do you think we shouldn't be doing? Where do you think if we look into stuff that we've crossed the line? If you're using a company provided laptop, should you be allowed to go to Facebook and LinkedIn and Twitter? And should you be allowed to just read there, or are you allowed to post there? Are you allowed to use your company email as your login and access to get into these social media accounts? Are you using your phone to post things about our company or about your personal views that are not in line with our company? So if you have a policy in place that tells people what they're allowed to do and what they're not allowed to do with your company equipment, with their company accounts, on company time, they're sitting in their office and they've got their personal phone, or they're allowed to go on Instagram and post things. Are they allowed to post things about your company on Instagram? Or are you like I was, where you said to every employee everywhere, hey guys, here's a company Facebook account, here's a company LinkedIn account, here's a company Twitter account. And we used to say, for example, every job posting that we make, we will link it to and post it on the company Facebook account, the company LinkedIn account, the company Twitter account. And we encourage every employee to repost that on their personal accounts. And so we had 540 desks across the country, 540 people, and we allowed them to set up auto reposting using an aggregator, so that whenever the company posted a job on its website, it got posted to 10 different job boards that we paid for postings on, and it automatically was sent to every employee's social media notification so that they could see it, and that their systems could be set up to automatically repost those again. And so if we had 500 postings across the country, it literally got posted thousands and thousands of times. We made that a thing. We're saying you are not mandatorily required to post anything of a corporate nature to your personal account, but we encourage you to do that. But you're not allowed to post anything about our company and say anything about our company unless it's a repost of a company post. In other words, you can't go out and say we're hiring all on your own. You could say we're hiring if it's a repost, but you're not allowed to go write it yourself. You're not allowed to say my boss is a dork because they did these dorky things. Not allowed to do that. So we said to people, we are so publicly domain driven. We want everyone to see 1,000 pathways to our website and to our job boards. And we're going to repost things in a way we encourage you to repost. But we also limit you from writing anything positive or negative about our company without being previously approved by your supervisor. So having a policy then makes it clear to people as to what information you're protecting about them. So, for example, you could say to people, here's our company profile on LinkedIn. If you want to show up as an employee of our company on LinkedIn, then here's the thing you put on your profile, and here's the link to our company thing to say that to our company page saying you're an employee. If you don't want the world to know on your LinkedIn account that you're an employee of our company, don't put it there. But you're allowed to put it there if you link it this way. That you are, and it'll probably show forever afterwards, unless you remove it, that you were an employee of our company in the future. And so creating a written policy that tells people what equipment they're allowed to use at work, what they're allowed to do during working hours, what they're allowed to do with the company provided equipment, what they're allowed to post and what they're not allowed to post. This will help you to do two things. One, to control your persona in the public domain by not allowing personal private information to be shared by people through social media to cause harm to you. And it allows you to promote your company in a way that is controlled and defined by encouraging people to post things that you post. It allows you to reprimand and hold people responsible for a policy that is written and understood. It becomes part of your employment agreements that they know that that policy exists and that they understand it and they're going to adhere to it. It allows you to then maybe even use that as justification to fire someone or to demote someone. It protects you from people sharing unwittingly, unknowingly sharing personal private information through company systems that maybe they didn't even know were being shared. So it protects you from being accused of sharing their information. But that of which is written and documented and put into a contract and agreement and is made open and transparent to your employees reduces the likelihood that there will be conflict in the future and improves the likelihood of there's compliance. And if you're a maverick employer that leaves that gaping hole of social media, then you've left yourself vulnerable to all kinds of problems that are undefined and unknown and unexpected in the future. And heck, you might not even know they exist if you don't have a policy that's in place. So if you ever want to have a special session on companies' best practices with respect to social media, let ACSESS know. Although in your ethics and business practices session, we're going to deal with some of this stuff again. And there we are, 10 minutes early as promised today, come to the end of our session. Please stay on the line. Ask me any questions that you want with respect to the issues that have been covered yesterday and today. And all you need to do is click your little button to unmute and jump in and take turns in an open conversation. So please do that. But also want to remind you, we're going to be back together, I think, next week for sales and business practices and ethics. Strongly recommend that if you have got a choice between recruitment, selection, and sales, that you do both, not just one or the other, although you are entitled to do one or the other between not recruitment, interviewing and selection and sales. You're allowed to take one or the other in order to qualify for CPC. Strongly recommend that you do both. Please, with respect to your membership and ACSESS, your company is a member, but you as an employee of that company have got access to all of the, spelled differently, ACSESS Association, online information and website. And so we don't have a super sophisticated way for people to create accounts because people come and go and work for different staffing companies, and is that staffing company a member? So if you belong to a member company and you don't have a login to get into the members area of the ACSESS website, send Jennifer Trayer an email saying, hey, I'd like to get a login to the ACSESS website. I work for such and such a company. She will make sure that the email address that you're using is an email access of the domain of the member company. She will make sure they are a member company in good standing, which of course they are, you're here, you're listening to me. She will send you a temporary login for you so that you can go in and create your temporary login, then change your password to your own. And you will have access to the ACSESS member section, which will allow you to download things and find things and get recordings and do all that kind of stuff. And so I strongly recommend that if you're not, don't have a user login with Jennifer, to do that. And also to take a look at the dates of the upcoming conference in May in Toronto. And if you're not registered for that, I started to tell you yesterday that all the things that I have learned in this industry have come from other participating members by attending conferences here in Canada and around the world of people who are in our industry, sharing information about their experiences, knowledge of the industry, and that this stuff isn't learned in school. So if you want to continue your professional development and build your network and continue to develop your professionalism and success in the industry, then most of the best people attend conference. So put it on your agenda, and hopefully we see you there. And if we don't see you there, we'll see you next week in our sessions for business practices and ethics and sales. Okay, so listening, waiting, nobody's jumped in. Hopefully that means you're still awake and you're really happy, and we'll see you all next week. Thanks a lot. Have a great evening.
Thank you, Steve.
Thanks, Steve.
Thanks,
Thank you.
Steve.
Bye-bye.
All right, guys.